felony assault, burglary of a habitation, and now a failure to ID.
Your Honor, we have a case that's not on docket today, but she's got a warrant they filed on her last month for a case that happened in August. And she wanted to turn herself in. The case number is 2553 536. Brianna Beck.
You are Brianna Beck.
Yes.
Ms. Beck, you are now charged with theft. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
Judge, can I get the case number, please?
255-3536.
3536?
Ready?
Yes. On December 17th, 2024, an officer reviewed an offense report of a theft on September 17th, 2024. According to the report, the complainant reported that the defendant, known to the complainant by name and site, stole 2 espresso machines on August 9th, 2024. The complainant stated the defendant committed the theft at 3 other store locations. The officer reviewed documents that there were theft incidents at 4 home goods locations. The first incident occurred outside of Harris County, Texas. The second incident was investigated by the Harris County Precinct 4 Constable's Office. The third incident occurred on August 9th, 2024, where the defendant and an unidentified female entered the home goods and entered the line to make a merchandise return. Once in line, the defendant ran toward the back, where she selected 3 sets of sheets and then walked to the front of the store and rejoined the female in line. The defendant then placed the sheets on the counter and provided the cashier with her state ID. The system denied the non-receipted refund due to excessive returns without a receipt. The merchandise was then returned to the defendant. The defendant and the unidentified female then left the store, passing all points of sale without attempting to pay. The value was $599.99. The fourth incident occurred on August 9th, 2024. The defendant arrived alone at another home goods location and proceeded into the store with an empty shopping cart. The defendant selected 2 espresso machines and then walked to the front of the store and passed all points of sale without attempting to pay, and the security sensors went off. The value was $999.98. The officer reviewed the surveillance footage from the third and fourth incidents and compared them to the defendant's previous booking photo, and they were a match.
All of Marshall's Home Goods? Is that what it is?
Yeah.
Okay. She's on bond for a theft. She's on bond for a gun case with us now. Where's the first theft?
The first theft is from a Walmart, Judge. $121.
Ms. Beck, I'm going to find that there's probable cause to go forward with the case, and I'm going to tell you now, I will do everything in my power to protect every person, place, thing in this county. And if I have to put you in custody and make your bond $50,000 because you continue to become a danger to our city, I will do it in a heartbeat. Do you understand me? I'm ordering you not to go to any Walmart, any Marshall's Home Goods, in anywhere. And I'm going to put a GPS monitor on you so I know where you are at all times. You are not to consume alcohol or illegal drugs. And I'm sending you now for a test so I know what, if anything, is in your system. You're to test and then you're to come right back. Do you understand?
Yes, sir.
Do you have a job at this time? What do you do for a living?
I'm a reservationist.
Okay. I want proof that you have a full-time job because that is now a condition of your bond as well. I want to make sure that you're working full-time as well.
And Your Honor, the defendant is also a complainant in this court as well. I need to bring up, we've reassigned these cases so that we can deal with it, and so it's on separate prosecutors. Like, I have the other defendant's case assigned to me, and Abigail is assigned this case. She is listed as so she is listed as the complainant in a separate case also in Court 5.
In what regard?
So she,
Like in an assault or something like this, of this nature?
yes, it's an assault, Your Honor. And to
Okay,
avoid.
so you divvy it up how you want.
Yes.
Yes.
Is that I don't want her to pick up fourth case.
Right,
No, we just want to
Sure,
make you
that-
aware, Your Honor.
yes.
I'm also ordering you not to be in possession of any weapons. Do you understand? These are your bond conditions. You violate these conditions, I'm going to revoke all of your bonds and I don't understand why you're having attitude.
I don't-
You have now 3 cases. You're rolling your eyes as if you have some kind of need to talk about bond. What do you suggest as far as a bond in this case, on the newest theft case?
We would suggest a surety bond on the case, Judge, and leave it up to your discretion in terms of amount, but I don't think a PR bond would be appropriate here.
Well, if you do, make it a surety bond, we could ask for it to be, low. She did show up here on her own volition today. And I think she's at least for today showing the right attitude about how to handle this from here on in.
Set your bond at $2,500. Cash a surety. No more PR bonds. Do you understand? I want to send her for a drug test right now. So Felicia,
Judge, I can't send her until the bond has been posted, or else they'll take her into custody.
okay, then I'm going to give her a PR bond for now because I want to send her right now.
Yes, Judge. I'll still have to wait till that process.
Yep, go for it. Okay, I'm going to set the bond at $2,500. I'm going to give her a PR bond because I want to send her for a test now. You were to test and then you're to come back. Do you understand? Not leave until you sign our bond conditions. Please take a seat.
Do I have to be back here when she returns?
No, I'm not. I want to know what, if anything, is in her system, but I want proof within a week of today of full-time employment. Okay. And then depending on what happens with the test, when we come back in a week, we'll talk about how to go further. Okay. Thanks. Sir, you are charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Sorry, Your Honor, I think I got the wrong cause number.
It's 2-555-746.
On March 15th, 2025, at approximately 2:15 a.m., the officer observed the defendant's vehicle failing to maintain a single lane of traffic. They also observed the vehicle to signal a lane change, failed to signal a lane change multiple times. A traffic stop was then conducted. The vehicle pulled over and the officer made contact with the defendant, the driver, and sole occupant of the vehicle. The officer observed a strong odor of alcohol on the defendant's breath and person. The officer then had the defendant step out and they observed the defendant to have red, glassy eyes and be unsteady on his feet, and stated that he had 1 beer at a friend's house. The officer conducted SFSTs on scene. 6 out of 6 clues were observed on the HGN. 4 out of 8 clues were observed on the walk and turn, and 1 out of 4 clues were observed on the one-leg stand. The DIC was read to the defendant, and the defendant consented to provide a breath specimen. The results were 0.136 and 0.139.
What was the stop for again?
The stop was at 2:15 in the morning. He was failing to maintain a single lane of traffic, and then he also failed to signal a lane change multiple times.
All right. Mr. Turrubiates, I'm going to find that there's sufficient probable cause to go forward with your case. Can you run him to see if he has any prior DWIs, please, and a license?
He does have a license and insurance, Your Honor, no prior history.
No prior DWIs.
All right. I am ordering you as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, your bond will be revoked. You will go to jail. No more PR bonds. Do you understand?
Yes, sir.
Because you have a lawyer, I will waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with counsel and he'll tell you if and when you have to come back to court. If he tells me he can't get a hold of you, you pick up a new case, you drive without a license, or it's not going to go well. Do you understand?
Yes, sir.
Okay. I'll have you sign a receipt of Victoria. You'll get with Felicia for your bond conditions and you guys are free to go.
Thank you, Your Honor.
Thanks.
Can I have excuse?
Take care. Hey, good morning. How's it going?
Good. How are you doing? Yeah. I have David Duran on the docket,
Okay,
and if the court has the time, I'd like to address the probable cause.
okay, absolutely, of course. Are you ready?
Yes.
Okay, please.
On January 11th, 2025, an officer was on patrol and observed the odor of marijuana and a male to be smoking in a motor vehicle nearby the 8,700 block of Lazy Brook Lane. The officer activated his emergency lights and positioned himself behind the motor vehicle and made contact with the defendant. The officer had the defendant step out of the motor vehicle and advised the defendant that he had been observed smoking marijuana. The defendant stated he was smoking marijuana inside the motor vehicle because he did not want to smoke inside his friend's home. The officer observed the strong odor of marijuana. A probable cause search was conducted of the motor vehicle, and the officer observed small crumbs of a green leafy substance known to be marijuana based on training and experience at the bottom of the center console of 0.37 grams and a small marijuana joint in the ashtray of the cup holder. The officer observed an unholstered black Glock handgun laying in plain view on the back seat floor. The defendant stated the handgun belonged to him.
So the way she's read it, there is probable cause. However, the way I read the DIMS, the officer initiates his lights first and then approaches the vehicle, sees him smoking, observes the odor, and then, so I think he's made the...
If that was right, yeah, but the way that she read it, and perhaps maybe you saw something different, I don't know.
Reading the DA's summary of it, I don't think she actually read the DIMS version, which is what I read.
Oh, I can read directly from the DIMS if you would like me to, Judge.
Maybe I think you should, because the way I read it, it was the stop first and then the observation that he's smoking marijuana.
I'll read the DIMS.
Well, but nevertheless, I mean, is that what happened?
So I'm looking at it right now, and I'm seeing that the vehicle was observed to be parked on the public roadway. He observed the male, he observed a male sitting in the vehicle, and it was parked on a public roadway. Upon observing the male, he positioned himself behind the vehicle to make contact with him upon approaching the vehicle.
And then initiated his lights.
Yes, he activated his lights before he positioned himself behind the vehicle.
I mean, sometimes they're incomplete, you know?
Yeah, the way I read it, he puts his lights on, gets behind the car, approaches him, sees him smoking, and then...
I mean, right, you can't put the cart ahead of the horse, but I mean, in that instance, I think that if he sees him smoking, right?
Yes, Judge, and I think that issue.
Smells it.
My argument is that he sees him smoking and smells it
Oh.
after he's been detained. He's not free to leave at that point because he's positioned his car behind the vehicle, put his lights on, he's detained.
I don't know. From what she read, I think there's probably.
Yeah, and in the first sentence, it says that he observed the smell of marijuana and the male to be smoking in the vehicle nearby.
Maybe we can look at the video and see
Do that.
how it reads.
Okay.
Do it.
Okay.
Take a look at the video. You see something different, you can always come back.
Sure.
Here. And I'm always willing to see it again.
Okay, thank you for doing that, Judge. Appreciate it.
Angel Melendez on docket. And there were the issues with the PTI and skip test. I've been speaking with him, and I think if we can do a scram device, I think that'll work. He's working at Taco Bell. He's never had any positive tests or anything, and his hours are kind of crazy. He'll work, night shifts and then typically 10-hour shifts.
Hold on a second. He's on PTI now.
Yes.
He has violations,
Yes.
right? Angel Melendez, come up. I don't know if it depends on how well he's been doing, what he's been doing, if he's done anything.
Yes, I know.
I'm not going to just blindly reset someone if he's not done anything, Mr. Melendez, you were placed on the diversion program and you're here now because there are violations. What's going on, Shatori, with Mr. Melendez?
Well, they aren't asking for an extension. They're just making the court aware that he's averaging 1 to 15 skip tests each month. The probation officer has talked to him about it, and he's saying it's because he forgets due to his work schedule. He's currently enrolled in IOP, and he has to complete the DWI education and cleaning duties. And he's set to do that on March 26th.
Okay, I'll agree with you. We'll put the scram on him now.
I think that'll solve.
Failed to pay for it. If the battery goes dead, so will this case. I'm not going to entertain anything else. You have any more violations, that's it. Do you understand? You will be put to trial. Okay?
I was going to see if we could waive the court costs on this because he is providing for his family and I was appointed.
He's in the program. I can't pay for it.
Oh, it's the PTI.
If he's on bond for something, then I can pay for it, but he's in the PTI program. You're responsible for all the costs. Now you're going to foot a bill of $500 a month for this thing. I mean, actions have consequences. And I'm telling you, if you fail to keep up with this device, the first instance, and I'd like to keep up, on a weekly basis, just to make sure you're out. That's it. Okay, Hugh.
Okay.
All right. So, we'll send him today to get it. All right, Hugh. Thanks. Ms. Jackson.
Good morning.
And you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. You've worked out an agreement that they're offering you 3 days in jail with credit for the 2 days that you've done. You need to understand that this charge will go on your record. It's going to be there for the rest of your life. This now makes 2. What happens on the next one?
I think the jail time might become a felony.
Prison time. That's what you're looking at the next time for a pack of gum. You could be looking at many years in prison. Do you understand?
Yes, sir. I do understand.
You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, this will go on your record. You can never take it off. Not only that, from now on, you're looking at a minimum of 90 days in jail for any new cases that you pick up. Do you understand?
Yes, sir.
All right. How do you plead to the offense, ma'am?
Guilty.
I'm going to find you guilty. I'll send you to the 3 days in jail, give you credit for the 2. Please see the clerk. Thanks. Sure. Are you appointed on? Is he appointed?
Yes.
Yeah. Yeah. So Jones, what time does court start?
What was that, sir?
What time does court start?
It starts at, I believe, at 8:30, Your Honor. I deal with the mental
Try
MHMR.
to get here on time.
I will.
Not only that, this is now your second PR bond.
Yes, sir. I see.
Fail to appear one more time, it's not going to go well for you. Do you understand? We don't continue to give PR bond after PR bond after PR bond after PR bond. We don't do that.
Absolutely.
Okay. You're charged with theft,
Yes, sir.
facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Absolutely.
On February 11th, 2025, at approximately 4:48 p.m., an officer met with the complainant, who is the supervisor for a roofing company. The complainant stated the defendant is a friend and had been working with the company for about a week. The complainant stated that on February 11th at 8 a.m., the defendant was supposed to be at a job but never showed. The complainant called the defendant, and the defendant stated he was at the hospital but would not give the complainant the location of where he was at currently. The defendant eventually met up with the complainant to give him the keys to the company vehicle, and the defendant's employment was terminated. The complainant pulled over and did an inventory search of the vehicle and noticed tools and equipment went missing. The complainant called the defendant and asked where the tools and equipment were, and the defendant stated he removed them so his girlfriend would not take them. The complainant called the defendant multiple times to get the tools, but the defendant blocked his calls and did not answer. The total value stolen was $2,000. The complainant stated 6 hours passed attempting to contact the defendant, and the officer tried to contact the defendant, and the defendant did not answer. The officer ran the defendant's information given by the complainant, and the complainant positively identified him by a photograph.
Mr. Jones, I find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to have any contact with the complaining witness in this case and not to be in possession of weapons. Do you understand?
I do not, because I don't know who the witness is. What is their name?
Person that you were working for at the construction company that gave you the car.
What was their name, Honor, please?
Tristan Weathers.
Tristan Weathers. Well, on my paperwork, it says Tristan Sanders. I don't know who Tristan Sanders is. So Tristan Weathers and Tristan Sanders are two different people.
I'll file under bond conditions as Tristan Weathers. I'm not sure. I can look. See if there's already.
I was showing the paper. Oh, paperwork. Yes, sir. This is paperwork. Say his name on
The
it.
judge requests it, nothing comes out.
It does say Tristan Sanders on the,
It says Tristan Weather here on the complaint.
okay, yes, and I believe that is his name, but on the bond conditions, it's stated as Tristan Sanders.
I don't want you to have contact with this person. Do you understand?
Tristan Sanders, Your Honor, or Tristan Weathers?
Weathers.
It said Tristan Sanders on the thing, so I'm
I'm
confused.
telling you now, I don't want you to have contact with the complaining witness in this case, whoever it may be.
No problem. He's on parole for 60 years. I don't even want to go around the guy. Yes, sir. But on the paperwork, it says Tristan Sanders, and they have that property. But my lawyer, Val Zubini, is going to talk to you or talk to you, represent me. It's just so much stuff, and I'm dealing with. I suffer from PTSD PTSD, and I'm hyper. So I'm just trying to take in all the emotions. I'm not mad at you, Your Honor. I apologize for being late to court. I was in the Navy, and I've been to the penitentiary. So I duly apologize.
Relax.
Yes, sir.
No one's going to do anything to you here.
Yes, sir.
The only thing I want is I want my city protected.
Yes,
And
sir.
I'm going to do everything in my power to protect it. I want you to understand that. Do not pick up any new cases.
Yes, sir.
Be nice to everybody that you go around.
Absolutely.
Because if you're not, it's probably not going to go well. Exercise patience and things will go well for you.
Absolutely. It has. Thank you.
Do you have the ability to hire a lawyer or would you like to apply for a court-appointed lawyer?
As of right now, you can give me a court appointed, but I'm going to hire Val Zugini. But Val, I just due to the simple fact I'm trying to get protective order. That's why I was late last time because my fear.
Just don't talk. You have the right to remain silent. Anything you say, they're going to use it against you. So it's best not.
That's
I'll
cool.
provide you a lawyer today.
It's true.
Tell everything that you want to say to the lawyer, and then they can come and talk to me if they need.
Yes, Your Honor.
Okay? Just don't miss any court dates
Yes, Your Honor.
and stay in contact with the lawyer that we give you.
I have a question though. So the last time I came, I was my fiance.
You haven't come here.
Yeah,
It was the first time that you've come here.
Correct. I'm incorrect. I came the last time at 12:30 because my ex-fiance had my cell phone. I talked to one of the ladies in the back, and I talked to her.
Hold on, Mr. Jones. I don't want you to say anything else. Let me give you a lawyer.
I don't want you to know this is my second time coming. I came to court. I just came late.
It's not a big deal.
Yeah, I know.
Let me give you a lawyer. Just hang tight for me, be patient, and then we'll find you someone, okay?
No problem. Thank you, sir.
Don't leave until you sign our bond conditions.
I'm not going anywhere, sir.
Good stuff.
Thanks.
Good for me.
Not yet. We need them to file. Oh, I already have them. I got them.
I talked to you last time.
Right here.
This is what I talked to right here.
We just need you to sign a reset real quick. You're good?
Yes, Judge.
Yeah, please.
Come back. When I went downstairs.
Ms. Fonseca, come up.
Yes. I was gonna reset it so I can look at everything. That's all.
I don't know about waiving it though.
No, that's fine.
How old is this case? You know? It's the case that we just had on Mr. Jones.
Okay. It's from, the new theft is from February 11th, 2025.
The new, how many cases is it?
Sorry, I thought that he had multiple. No, the theft is from February 11th.
Mr. Jones, come up. I'll waive it. I thought it was old. It's not an old.
It's up to you. I don't care what we're doing. Whatever you want to do, Jeff. Who wants to be here?
So, Mr. Jones,
Yes, Sean.
I've given you a lawyer.
I thank
Okay?
you.
So I usually waive people's appearances, meaning that you don't have to waste your time coming to court, but you have to stay in touch with him. If he tells me he can't get a hold of you because you're not answering his phone calls or text messages, I'm going to issue a warrant. All I'm asking you to do, don't get in trouble and stay in contact with him. That's literally all I'm asking you to do. Don't get in any trouble.
Yes, sir.
Do you understand?
Yes, sir.
All right, we're good. He can't leave yet because he has to sign bond conditions. As soon as he signs it, then we'll let you go. Okay, they're creating bond conditions. So you promise us that you're going to behave. We'll have you sign it, and then after that, you'll be free to
I'm
go.
not a better version, Your Honor. It's just looking at on paper. I changed my life.
I got you, man. We'll trust you.
I've
That's why
been
you're out and about with us now.
doing a lot for the community.
Just stay in contact with him, okay?
Give me my number once we're done, okay?
Can I tell you something though? I actually was on the news last year with Kim Hall, Judge David. They did a story on me in Channel 2 News. I was on the news. They used my story for the company I work for change for mental health.
That's great.
And I was on the story for Kim Hall and Judge David and Chronicle. So I've made a bunch of changes. This is a mistake, and I just get so emotional when it comes to it. But I apologize.
Don't, because remember, they can use anything that you say.
I got you.
Just,
No problem.
Let me look at everything.
No problem.
We'll figure everything out, okay?
Thank you.
Okay.
Judge.
all right, so take a seat, but don't leave until we let you go.
All right, have a seat.
Thank you, Mr. Jones.
Okay, and then I got one more judge. This is, gonna be Vanessa Gonzalez. They're still trying to get a RIP call done, so, there's not a RIP done yet. So I'm just gonna reset that. It's 189 days old, that's why.
I mean, how long, we're now 3 months waiting for a RIP?
Right, and we've attempted to contact him multiple times.
People don't want to be found, we want to be found. I'll give you a week. After that, just proceed as if without, Okay?
And she is here. Can I waive her appearance?
Yeah.
Thank you, Judge.
Lori Gooch. Lori, you're up.
I'm sorry.
Good morning, Ms. Fonseca. Ma'am, you're charged with assault of a family member. You have worked out an agreement. They're offering you 90 days in jail with credit for the 35 that you have already done. You need to understand that there are a lot of serious things that are happening right now. You're pleading guilty to this offense. This offense will go on your record. There's also an affirmative finding of family violence. What that means is that if you ever pick up another case like this, you will be facing a third-degree felony, a minimum of 2 years in prison, a maximum of 10 years in prison. And it doesn't have to be a drag-down fight. You just squeeze the arms enough to where it hurts. You're looking at up to 10 years in prison. You understand? You could never own a gun or ammunition as a result of this plea as well. You're giving up the right to a trial, right to compel witnesses, testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, this will go on your record. You can never take it off. Is this what you want to do? Are you on probation or parole at this time?
I just started probation on the 17th of March. I just pled out to a felony CW and got deferred, but she's going to a program. Yeah.
But make use of that program. If you have some kind of addiction issues or whatnot,
Sir.
I'm telling you, there's only so many times they're going to let you go before they send you to prison.
Sir.
You understand?
I understand.
All right. Good luck, man. Thank you, Ms. Gooch.
Thank you, Judge.
Yeah, it's John.
Hi, Yasha.
How are you, Judge?
What's up, man?
Not much. Crazy day, but I have a plea ready for Mr. Lamont Edwards.
I'm ready when you are.
Ready? Okay.
Yeah.
Mr. Edwards?
Good morning, Mr. Edwards. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. You have worked out an agreement. They're offering you 6 days in jail, credit for the 2 that you've done. You need to understand that this charge is going to go on your record for the rest of your life. You get pulled over, an officer's going to look at your record. You smell like alcohol or dope. What do you think they're going to do? Right. What we're doing today, from now on, you're facing a minimum of 90 days in jail for anything that you pick up. Do you understand?
Yes, sir.
No more proverbial slaps on the wrist. So if I were you, even if you have one toke, a sip of alcohol, don't get into a car. It's a huge risk. You understand?
Sir.
You're giving up the right to a trial, right to compel witnesses, testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, you can never take this off or undo this. This is what you want to do.
Sir.
How do you plead to the offense of driving while intoxicated? I'm going to find you guilty. Follow the agreement. What do you do for a living, sir?
I'm actually disabled. Disabled.
What's the nature of your disability?
I was with,
Okay.
what's the disability? So
What's your disability?
my health issues.
What kind of income do you have coming in?
That SSI.
You need to understand that DWI is big business. There's a $3,000 surcharge that would normally apply to this. I a lot of times waive it on first offenses because you know what? We all make mistakes. But I'm going to tell you now, if you continue to make mistakes where you endanger my city, a second DWI, it's a $6,000 surcharge. And you don't pay it, you do 1 day in jail for every $100 you owe. So on a $6,000 to $7,000, imagine how much jail time you'll do. Don't pick up another DWI because it's really not going to go well for you. You understand? All right. Good luck. Oh, I'm going to suspend your license for 90 days.
Judge, you had an ALR suspension for 3 months. It just got reinstated on the 16th. Is there any way we could get?
Let me see. Does he have any bond violation or anything like that?
No, there was no bond.
He's behaved good?
Edwards.
Edwards? No bond violations or anything?
No, Judge, none that I see.
All right. I'll do it for you. Don't pick up another one. I'm telling you, 90-day minimum and a $6,500 surcharge. You understand? Okay, man. Good luck.
Thank you, Judge.
Thanks.
Wait, DPS, the rent and subject?
Yeah, let's go. Good morning.
Mr. Jose Borrego here.
Okay. I'm going to send him for a test now.
He got his test this morning.
So presumptive for THC.
Come up. Come up.
If I may make an argument, Judge.
Sorry, who was the client?
Jose Borrego.
Yes.
He tested positive for THC. He signed bond conditions January 27th. THC can remain in the body for 30 or more days, depending on depending on how much you smoke, depending on body fat. It's currently been close to 40 days, I think about 40 days since signing the bond conditions. If you can,
I'll give you 10 days.
10 days, we'll take it.
It must be back here in 10 days to test. If you test positive, do you understand me? Okay?
Thank you,
Send it.
Judge.
10 days.
Okay.
Take a seat for me. So, Ms. Strom must be here in 10 days.
Absolutely.
He tries to make an excuse that this, that.
He'll be there.
All right.
Thank you, Judge.
Catherine Herrera? Ma'am, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. You've worked out an agreement. They're offering you 3 days in jail with credit for the 1 day that you've done. You need to understand something very important, that this charge will now go on your record. It's going to be there for the rest of your life. It's even there after you die. If you get pulled over in a car, an officer's going to look this, they're going to see this. If they come up to you and they smell alcohol or dope, it's probably not going to go well for you. And what we're doing today, from now on, you're facing a minimum of 30 days in jail. No more proverbial slaps on the wrist. Do you understand? You give up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers, the right to be arraigned, charged, read in open court. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty to this offense, ma'am, it will go on your record. It's going to be there for the rest of your life, like I said. Is this a true first?
Yes, Judge.
Okay. No PTI.
No, Judge.
Okay. How do you plead to the office, ma'am? Guilty or not guilty? I'm going to find you guilty. I have to suspend your license. I will suspend it for 90 days. Ma'am, there's also one more thing you need to understand, that DWI is big business in this state. There's a $3,000 surcharge that would normally apply here. I'm not going to tack on to you now, but if you come up here with another DWI, a second DWI, it's a $6,000 surcharge. And if you don't pay it every day, or I'm sorry, every $100 you owe, you will sit 1 day in jail of that $6,000. Do you understand? Don't come back. Otherwise, it's a minimum 30 days in jail and then a boatload of costs. Good luck to you, man.
Thank you.
Thanks. Check.
I'm here on 2 cases, and I hate asking you, as I told Chief, for more time on both of them, but both of them have comp evals pending. The first one is USADA. Victoria did send an email to Helena and copied me on it to get the schedule, and I unfortunately dropped the ball on it, but I did get
It's
it.
307 days. I don't understand why. Where is USADA now?
She's here, Judge, but it was my fault because I didn't get it scheduled, but I took care of it during docket, and I have a date for her now.
What's the date?
March 31st, I think. Let me look.
Okay, great.
Yes, March 31st. And it's at 8:30 a.m., so hopefully we can get that done and get the report back. So that one was my fault.
Is there
So
an offer on this case? Is all evidence?
all evidence has been shared.
Okay, so then you said the day's March 31st, so
yes, Judge.
April 1st, you got to be here. It's plea or trial on that day.
Okay. Hopefully they can have the report back by then. Do you know if they get it
Oh,
around that quick, Judge?
I don't know. I mean, oh, I forgot. I don't know. How long does it take to get the reports from Helena?
Yes, about a week.
Say it again?
I would guess about a week. Push
Okay.
is two.
So let's set it a week after to try to get the report.
Sure. April 9th?
Sure.
Sounds good.
The
April 9th.
clear trial in the next setting though. Must.
Okay. And my second one is also very old, but these were from like 2020, 21, I think.
Is it?
Housel Demoria. There's also a complaint pending on him. He also has a felony pending, and I have medical records. He's being treated at the Harris Center right now.
And-
So that one, I don't know. I know it's probably,
Yeah, but I mean, all ours are from 2022, 2021. I'm not waiting for the case upstairs to resolve for ours. So,
I'm not either. These are different transactions. I'm not really worried about if they're doing the felony for different transactions. It's just become eval.
it's been done?
the comp eval has not been done yet. But he's been at the Harris Center, so I'm gonna email Helena and get that date also.
Can you
To make
get
sure.
now?
Yes, absolutely, Judge.
Okay. I'm not doing any more long resets. This case is 965 days old and it's,
It is, I don't know why it's so old, Judge. Maybe it was a 2B for a while, I'm not sure. Or maybe it was a bond forfeiture. I couldn't tell you.
I mean, we have a comp exam from January. Let me see. Hold on.
You have a copy eval from January?
Let me see.
That might be the motion by defense
Yeah.
counsel, but I think because there's already we can't rescind it, is my understanding now.
Okay, so I'm not doing any more long resets on this. So we'll set it for Monday just for you to get the date.
Okay.
Okay. And then hopefully we'll
Pretty-
get the date relatively quick and go from there.
She only took her like 20 minutes to send me this date on USADA, so I'm pretty sure we can get it pretty quick too.
Okay, you want to roll it to tomorrow or what do you want to do?
If we can waive his appearance, I can be here
I'm not
tomorrow.
waiting. It's 965. I'm not waiting any more appearances. It's just too old. You know,
Okay.
I mean, I guess take some time. Let's see what she does. And, you know, I'll give you the same type of reset that we did on
Okay.
this past one. If you want to wait a while to see if you can. Otherwise, we can roll it for a couple days for you to get date, but I'm not,
A
it's
couple
just
of
too
days
old.
might be better because I know his mom has to bring him because he doesn't drive with the medication he's on for his schizophrenia.
I understand.
Okay.
But I mean, at nearly 1,000 days old, I'm no more long resets. I mean,
Okay.
until the day after the next, or a week after, just to get the report.
That works. And the mom is getting medical records for me too as well. So he should have that by this afternoon.
Hopefully. Okay,
Thank you, Jared.
thanks. Yes, ma'am. Since 2023, you have picked up a disorderly conduct of discharging a firearm, felony assault, burglary by habitation, and now a failure to ID. No, I'm not going to accept. You need to understand that I, as the judge here, do not have to accept a plea bargain agreement in this case, and I'm not going to. I will not accept the time served, and I'm ready to set this thing for trial. You're looking at, you know, a year on the disorderly conduct, and I think it's unacceptable with all this and his lengthy criminal history. It's unacceptable to do. So I'm ready.
I believe the disorderly conduct is class B.
Yeah, it is charged as a B. Regardless, I mean, I'm not ready to accept the time served on these cases, not with this criminal history and not while he has picked up all these cases, 3 felonies while on
What would
bond.
you accept?
I don't know. But something significant. It's just too much, Mr. Portillo, and you're not getting it. And it's time.
He
So
does have 22 days credit.
that's,
I'm just trying to find out
I understand.
what you.
But I'm ready to, I mean, I'm ready to set this thing. Yeah. All right. So
What? So would you accept anything?
I don't know. I don't know.
I mean, I would say I don't believe the state's spoken to their witness on the Class B disorderly conduct case. So
This is
I understand.
100 and something days.
I understand, Your Honor.
That.
And I know you just got in here, Blaze, so
And with that, felony. Complainants,
same complainant as the felony assaults?
sure.
Yeah, nothing under 180 and unacceptable. No. So we do that or I'm sending it for trial.
So 180 days. Okay.
Or yeah, 180. I mean, we have a disorderly conduct now, 2 felony assaults, a burglary and he's a fugitive from justice on the failure date. No,
Would
it's
you
unacceptable.
A probation or would you? I'm not saying. Just trying to ask. So no.
I don't think state can really offer probation.
And
Okay,
I
all right.
not with this kind of baggage. No.
Okay. Okay.
Yeah. So you guys decide what you want to do and let me know. And then we
So it'd be 180 days minimum.
yeah, I'm not, it's just way too much baggage. No, it's time to,
Well, I just want to know just if we should even try to negotiate because I don't want to do that and then
I mean, I'm okay with that. I'm okay with that if that's what you guys
So-
want to do. Otherwise,
anything 180 days. If you please to want to dismiss one.
I'm okay. If you want to do that, sure.
I'm not saying we're going to take that. I just want to know.
I get it.
Okay.
I get it.
If we,
I mean,
if I could have 5 minutes with my client and then we'll.
Mr. Elick, come on.
I know. I'm just.
Take your time.
Thank you. Okay.
If you found this video informative, please like, subscribe, and turn on the bell icon so you never miss the latest courtroom hearings, legal updates, and case analysis.